There's a
All right,
screen right
good
in front of you,
morning.
right where the
Welcome
voting is.
to our November 15th public hearing. We have a number of speakers today, starting with item 1. I have Matthew Sabaugh. Is he present? We'll come back to him if he joins. Scott Bassett. Mr. Bassett, are you there? We will move on to our third speaker and circle back and see if they have joined us. Karen Moragian.
Yes, good morning, Your Honor. Karen Moragian.
Sorry for mispronouncing that. Hi, Karen.
That's okay. Good morning.
Good morning.
Morning. Go ahead and proceed.
Oh, I'm sorry. I disagree with rules 1.109, 5.302, and 8.108 in its entirety for the following reasons. My mother's death certificate, in my opinion, contained fraudulent information. And if it weren't for PII, I would not have been able to discover that information. Her power of attorney is a Michigan bar licensed attorney who is extremely unethical. She listed her home address as my mother's last address before death. My mother was in a nursing home from the end of December 2020, and she died there in February of 2022. My mother never lived at that address at any time. And this is critical that family members are able to have this PII information, because there are unscrupulous attorneys out there who unfortunately counsel their clients, don't share your estate plan, your wills, your trusts with family members. No ethical attorney would do that. And families suffer when that information is withheld from them. And how can they report fraud or waste or power of attorneys that are violating their fiduciary duties to the principal? The courts really, I'm sorry, not the courts, but the Michigan legislature really needed to add in that power of attorneys have to have a court order before they ban family members from visiting their loved ones. As you know, there are so many power of attorneys out there that they're so vindictive, they punish family members, and I was one of them. This attorney retaliated against me because my oldest sister is a nurse and reported all the horrendous care my mother was receiving. She threatened to sue the nursing home if my visits were not restricted. And then I was banned 3 days before my mother died. I have reported her to the AGC, even though I have well-documented proof of all of the numerous fiduciary duties she violated that she owed my mother. Nothing was done. She joined the Character and Fitness Committee under false pretenses. Nothing was done. And again, that's a little off track, but I implore you, please do not redact PII, because what are families to do if they don't have that information? How can they report fraud and waste? You know, and this is so imperative to protect families. And even though I wrote out all my comments, I just feel it's better to, speak like this instead of the notes. And I do want to stay within my 3 minutes. So I wholeheartedly thank you for allowing me the opportunity to address my concerns to you this morning, and please help protect these families and don't redact the PII, because these families have suffered enough. They're not being, you know, allowed the opportunity to know what's going on in the estate planning or the wills or the trust, and then it turns into probate contests and it just gets so ugly. We need to protect these families, and again, that's why I am against these rules, and I ask you to reject them. Thank you for your time.
Thank you very much. Any questions? Thank you. Thank you for being with us today. Our next item is item number 5, proposed amendment of MCR 3.613. We have one speaker, Jay Kaplan from the ACLU.
Good morning, Your Honors. My name is Jay Kaplan, and I'm for the ACLU of Michigan's LGBTQ+ project. I'm here to speak in support of the amendment to Court Rule 3.613 that would waive the cost of the publication of a hearing when the court orders a waiver of fees pursuant to applying for a legal name change. The ACLU of Michigan is part of a coalition that includes attorneys from Dykema and Ford, providing pro bono legal representation to indigent transgender persons in Metro Detroit for their legal name change. Over the course of 4 years, we've been able to assist close to 300 persons with obtaining legal name changes. As we have mentioned in previous testimony, having accurate identity documents like a name change is an essential part of the gender confirmation process for transgender people. Changing one's legal name along with changing their gender marker to match their gender identity and expression is considered by the World Professional Association for Transgender Health to be an important therapeutic option in the social transition process. The cost of obtaining a legal name change in Michigan is prohibitive for a large segment of the transgender population. It costs approximately $400. Transgender people face pervasive discrimination in every aspect of their lives, in employment, housing, education, and public accommodations, including access to healthcare. Transgender people are more likely to experience homelessness, are more likely to be victims of sexual assault and physical violence due to their gender identity. The most recent FBI hate crimes report shows that hate crimes against transgender people, particularly transgender women of color, have increased over the past 2 years. Due to this pervasive discrimination, transgender people are twice as likely to be living in poverty, 29%, as opposed to the general population, 14%. For transgender people of color, the disparity is even higher, with 38% of African American and 43% of Latino transgender persons living in poverty. The 2015 U.S. Transgender Survey found that 35% of those surveyed had not obtained a legal name change due to the costs associated with the court procedure. While we believe that the publication of notice of a hearing requirement is both archaic and no longer useful to the name change process, and many states have done away with this requirement, and that such requirement has the effect of outing transgender petitioners and placing them at risk for discrimination and violence. We believe that if such a waiver of publication is not granted by the court, then at least the cost associated with publication, which is usually about $100, should be included in the fee waiver granted. The majority of trans people that we provide assistance with representation are in limited incomes and simply do not have the financial means to pay this cost. In sum, obtaining a legal name change for transgender people is an essential component to their ability to live their authentic lives and an affirmation of who they are. Any obstacles or barriers, including financial costs, should be alleviated so that the transgender community has equal access to our courts. Thank you for your time.
Thank you very much. Thank you for joining us. And do we have speakers for item number 1? Oh, okay, then that concludes our hearing for today. The court is adjourned.